between the testimony of the officer and the testimony of Mr. Green at that motion that he recalls lights going on, I believe, upon his making a turn. And so that puts that at issue. And
I think the question is that it doesn't appear as if it would have captured anything anyway with regard to the stop.
Well, and I think that Benton, B-E-N-T-O-N, gets to that the testimony, I think, is at issue. Officer Schlidmeyer's testimony is in conflict with Mr. Green's testimony, that he recalls the lights coming on after he makes the turn, I believe. I'm trying to recall his specific language, but Benton speaks directly to that the appellant testifying that he disputes the testimony of the officer given at the suppression hearing, that the tape would have provided the only possible objective evidence of the events as they happened, and so that's.
Well, but he didn't dispute the notion that the video would have captured the turn signal or lack thereof, right? I mean, because there's no way that he could have.
Well, no. What I'm saying is more disputing the timing. Obviously, Mr. Green didn't have any knowledge of the inner workings of the MVR system, the timing of any of that. But the testimony of the officer is that he's waiting for backup. There's a delay between the turn and the stop, or the alleged lane changes, the turn and the stop. Whereas I believe, again, trying to recall Mr. Green's precise testimony, seems to indicate that the lights in the trailing vehicle and the trailing police vehicle would have come on sooner than that.
So, Attorney Weissman, I mean, naturally, it's a better case for you if the burden is shifted to the state. But ultimately, the evidence that would have been on the video, would that have been exculpatory?
Your Honor, I can't say that it would be exculpatory in any good faith, frankly. Obviously, yes, it would be, and the standard certainly says that, because of the request made of the state, that the burden shifts. But no, it would not have shown the actual violation or lack thereof. The felony violation. So then
what would be your argument with regard to bad faith and the evidence of bad faith?
Precisely. Yes, as to bad faith in particular, specifically turning to Dernwald and Riggins, I think that what we're looking at are what the state knew of this MVR information and how it would be useful. These MVR videos are, I don't want to be too categorical here, but they're almost always going to be at issue, and they are going to be of evidentiary value of some sort because they turn on when the lights come on, lights signaling some sort of stop, arrest, confrontation with police. The state viewed some of these MVR units as material enough to present at the motion to suppress, specifically the Officer Knapp's MVR. And so the helpful MVR happened to make it to the day of the motion to suppress. That the MVR that would not have been helpful to the state, or potentially could not have been helpful to the state, or potentially could have been helpful to Mr. Green, that did not make it. Again, the records were specifically requested on June 20th, 2018. They were requested before that in a demand for discovery, but the normal retention policy for Cincinnati Police Department would have seen those records deleted a full month later, July 20th, 2018. And so the bad faith results from the failure to retain this information, essentially. And like I said, in Dernwald.
But I think, is it your position that because everything else was provided and this was the one piece of evidence that wasn't provided, that evidence is the bad faith?
Well, that, in addition to, Dernwald specifically, the court says the utter failure to safeguard evidence relevant to a crime and arrest is sufficient to show the state acted in bad faith. There seems to be a categorical failure. And again, the record notes that, you know, Officer Schlidmeyer probably didn't go and delete this video by himself, but somehow this got deleted out of order with the normal course of retention. And it just so happens that that video could have potentially been useful to the defense. There has to be some sort of penalty for losing that information ahead of schedule. Even if Officer Schlidmeyer didn't, you know, go in the dark of night and tinker with the controls, the state of Ohio as a whole failed to abide by their own policies, and they're the ones that lost control of this data. I know that all the technical difficulties kind of threw off time. So if the court has any further questions, I'd be happy to answer. Otherwise, I'll kind of wrap up this portion of my argument just in the interest of time, not to waste further time from the court.
Are there any further arguments from the panel at this point? All right, thank you.
Thank you.
Attorney Steyer.
Good morning again, Your Honor.
Good morning.
Mr. Wiseman, may it please the court. So what we're looking at here is the question of whether or not it was materially exculpatory or not. Under Brown, because we don't dispute that there was a motion to preserve.
I think the key issue here is the bad faith.
Mm-hmm. Yeah, so moving to that, there clearly is no evidence of bad faith. Brown said that there has to be an indication of dishonest purpose.
Counsel?
Yes.
Just to clarify, we have no idea what happened to this thing.
We have no idea what happened. And so in this way.
But we do know that it wasn't preserved for 90 days, according to the policy.
I'm not sure. Well, I don't know I guess we can't find it, so we don't know. I guess it wasn't preserved. We're not exactly sure what happened with it. And that way it's like State versus Arnett that I cite in my brief, where if there's absolutely no explanation on the record, no hint of what happened to it, based on that, we can't say that there's any bad faith.
Well, but I think like the problem with that analysis is, and we've had these cases before where it's like this bureaucratic hot potato that everyone's like, it wasn't me, I didn't destroy it, it wasn't me. We never know like what happened. But it's concerning that there is evidence that the defense has requested that's being destroyed. And I understand the bad faith, I understand all of that, but how do we get people to pay attention to evidentiary obligations?
I think here, I know that there are some other cases, and I think back about, I can't think of the name of it, but when there was some question about some jailhouse recordings and whether or not maybe.
That was my concurrence, yes.
I know that one. But here, Officer Schildmeyer did everything that he was supposed to. The state did everything. Well, at least as far as we know, the state did everything. We submitted during the hearing on the motion to dismiss a list of our email where we're trying to get from evidence.com. That's where our evidence goes. All of our requests kind of tracking how we were trying to get it. We're not. It wasn't even like that case, and I'm sorry that I can't come up with the name of that defendant. It wasn't where there was like a long delay. Our assistant prosecutor was working on this, trying to get the evidence turned over, and Officer Schildmeyer had no clue what had happened to it. He said that there were some times where he would have looked at the video immediately in his cruiser. If, for instance, he was following a defendant and the defendant threw something out the window. Sometimes the police officers will look at it immediately. But other than that, it's completely out of the police officer's hands. A supervisor, once the hard drive gets full, a supervisor takes that hard drive, downloads it, replaces it with a new hard drive. And so there's absolutely nothing that Officer Schildmeyer can do. And we don't know what happened with it after that.
I mean, what we do know is that the motion for Brady material, the discovery request, and the subpoena were all filed before the 90 days. Is that
Yes.
correct?
Yes,
And we do know that everything was provided that was requested except for this one video. We do know that.
right.
Okay.
Yes.
Now, that other than the officer, did the state put on any other evidence in order to explain or to provide more light to what may have occurred with regard to that recording?
We did not, because I don't think we have any idea of what happened to it. We just, it was gone. And so all we had was Officer Schildmeyer's testimony about activating the camera, and that he didn't activate it until, well, he didn't turn on his lights, and that's how a camera is activated. And he didn't turn it on until 45 seconds to a minute after he saw the violation. And so unfortunately, that's all we have. But based on Brown, there's just absolutely no sign of dishonest purpose, moral obliquity, conscious with wrongdoing or ill will. All the evidence here is that the police officers did everything they could to get the evidence. And unfortunately, they were unable to get it. And in that way, it's like, I think Brown, where it was taped, where the, or I'm sorry, Heisling, where the recording, where the video was recorded over accidentally. And there's just that, where there's no ill will, you can't find bad faith on the part of
Well,
this.
but I guess if you had evidence that showed, oh, I accidentally recorded over that, then that would certainly negate bad faith. But I mean, what you're saying is you have no idea what happened to it. You have a couple people who did what they could to try to find the evidence,
Right.
but someone did maybe what they weren't supposed to do and got rid of that evidence. So I guess what you would say is that's not enough to show bad faith.
I don't think that is enough to show bad faith. I don't think, we're not sure that someone even did something that they're not supposed to do. I mean, there's always, for all I know, the hard drive could have failed in some way, or something could have happened with it. There's just absolutely no evidence at all what happened with this. Had this gone to trial, it could have possibly been something that he could have argued, as far as, it could have gone to the weight of the officer's testimony as far as what had happened.
Would he have gotten the benefit of a spoliation instruction or something like that?
I'm not sure that he would have, because I don't know that, without the state having done anything to, the state didn't get rid of the evidence. It didn't destroy the evidence. I'm
We
not
don't
even
know
sure
that
that it was
necessarily.
destroyed. Please, I'm sorry?
We don't necessarily know that. I mean,
Correct. But we also don't know that they did. We're kind of in an area where we don't know what happened with it, and the state took the steps that it could to preserve it. That's all the evidence that we have. Unless there are any other questions. It's all, I mean, we're pretty much stuck with the record we have. And we'd ask that you affirm. Thank you.
Thank you, Attorney Steyer. Attorney Weissman.
Thank you, Your Honor. I think the point I want to bring back is, again, Dernwald, an utter failure to safeguard evidence relevant to a crime and arrest sufficient to show that the state acted in bad faith. And, it's an oopsie daisy by the state.
Can you hear us?
Can you hear me now?
Yeah, we can. Thank you.
Oh,
You can continue.
okay. All right, sorry. So, yeah, Dernwald, the utter failure to safeguard evidence relevant to a crime and arrest is sufficient to show state acted in bad faith. The point here being that the state's response is that we've got an oopsie here that we just can't happen to find. We don't know what happened to it, but that simply can't be the standard. They hold all of the cards here. There's no potential for the defendant to have any outside access to this information. It is wholly held within the power of the state. Police officers, Officer Schlittenmeyer, it's on the record that the defense attorney says, I don't believe that Officer Schlittenmeyer did something nefarious. And I can't disagree with that. But the state of Ohio did something wrong, because that video did not appear after demand for discovery.
Did you try to subpoena additional state actors to get to the bottom of it, or could you have done that? I mean, I guess what steps could have been taken to try to get the answer?
I suppose that's a possibility, but the subpoena went out to Cincinnati Public Police Department on June 18th. It requested that somebody from CPD show up at the Hamilton County Courthouse on July 6th, which still would have been within the time of the retention period under CPD rules. And that was not done. Those records were still not produced. So there was an extra step. This isn't a case where defense counsel just happens to file their motion or their demand for discovery and waits for discovery to show up. They took the extra step to subpoena CPD and ask for this specific record, and we still don't get it. And we can't. I think
Ultimately, aren't you asking us to make an inference?
Well, I don't think so, because the information is in the hands of the state. When I say information, I mean
there's no direct evidence that there was bad faith. Do you agree with that?
Well, I think that there is an utter failure to safeguard the evidence. I think that has to be said, because the evidence doesn't appear at court. The evidence doesn't appear in counsel's hand.
So you're saying that the failure to preserve is in and of itself evidence of bad faith?
Correct.
And I think that's the inference that I'm talking about. You're saying that based on the fact that it was requested on a timely basis, and within the 90 days of the retention period, and that everything was provided but for this one recording, you're asking us to take that and say, well, that then establishes or infers that there was bad faith.
Yes, and I think that that's really the only inference that can be drawn. Again, because it is in the hands of the state, that this MVR data is in the hands of the state, and it is not supplied via subpoena as specifically requested. And so I won't repeat myself any longer. I thank you very much for your time. And we respectfully request that the court find in Mr. Green's favor.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. And again, it's a gorgeous day out there. Great day for a walk. Have a wonderful afternoon.
Thank you.
You too. Okay.
Thank you.